giving the argument. Thank you. Or if it's unintentional, and that means that they are the byproduct of carelessness or ignorance of either the standard of reasoning or the context of the proposition or the hypothesis that is being presented and that you have and you want to present to the other person. So we can have two main types of fallacies. First one is the formal fallacy, and second one is the informal fallacy. Despite what the name may told you or may imply, the formal fallacy is actually almost a mistake in the presentation of the argument that you are trying to make to the other person. That means that it's going to be an error on the logical expression of an argument. It is what we usually call a non sequitur. That means that the conclusions that the conclusions that you're presenting are not derived from the propositions, and the propositions are not derived from the hypothesis. Although the premises and the conclusions might be true, what it means is that the presentation is completely defective. And you're going to actually be able to notice this in your oral arguments in the Jessup, when someone is telling you that they do not understand the conclusion of the argument, or they ask you to elaborate a little bit more in how you are going to arrive to the conclusion that you are presenting. That means that from the first proposition that you're presenting, there is not a logical link that goes one to the other, and then a link to the conclusion. So basically, a non sequitur or a formal fallacy will be, I would say, it will be easy for you to save it while doing an oral presentation. In your written submission, a formal fallacy you're not going to be able to actually do anything about it, because you cannot go back on your steps while we are reviewing your written submissions. So the problem there is that you have to be extremely critical while you are writing your arguments and while you're writing your memorials, because everything has to be the logical consequence of the previous statement. The informal fallacy is a little bit more worrisome, because it means that there's a mistake of reasoning inside the argument by itself. And it's usually produced by a lack of understanding of the propositions that are part of an argument. So this means that we have an organic failure in the argument that is being presented to us. And by that, we have to try to understand and to know exactly where's the mistake that we are going to that we have here. So basically, what I'm going to try to do here is trying to explain to you the 10 most common fallacies in legal arguments. Most of them have very fancy and beautiful names in Latin, as ad hominem, ad authoritate, petitio principii, ad consequentia, marc ignorantia ad hoc, etc., etc., etc. So let's start. Ad hominem. As the name implies, it is an argument that is based on the quality of the person that is meeting the argument. So instead of trying to present the argument as true or false by its own premises, what we're trying to do is that the argument is going to be true or false, considering the person that is saying it. The most simple example is that most of the time we can call in epistemology ad hominem as ad Hitler. So it's like if I try to make a criticism of vegetarians, because Hitler was also a vegetarian. So all vegetarians and vegetarianism is wrong and it's bad. What I'm trying to attack here is that for one person and from the quality from one person, I'm trying to make an argument that is false by itself. So these ad hominem arguments, or these ad hominem fallacies, also can have several subtypes. The most common is one that is called tuquoque. And tuquoque means when someone or we're trying to convince someone that we haven't committed something because someone else did it too. So it's also when you try to prove that you are wrong or that someone is wrong because you are right, or vice versa. Also, we can have it derived from the other circumstances. That means that you're going to attack whether the person is the job that he has, if he has money, power, or the religion, race, or whatever other kind of discrimination that we can think of. So it's like saying that rich people cannot have an opinion about this, or that poor people are not allowed to have an opinion, or the reasoning about something is going to be completely baseless. Also, we're going to have this kind of abusive ad hominem arguments. You're not expected to do any of these arguments you give, and the abusive one is just is insulting the other party in order to make your argument prevail. That is not going to work, and that is not going to fly. We do have to understand that an ad hominem argument is not going to be a fallacy and can be considered true if the reasoning is based on the personal beliefs on the individual issuing the same argument. Let's say, for example, that we have a very Christian Catholic person, and it starts holding an argument for the death penalty. I would say that it can be a valid argument to start questioning that person's argument based on his personal beliefs, as it seems that its personal beliefs, being a Christian Catholic, are not actually in compliance with the argument that he is saying about being in favor of the death penalty. Then we have another one, and this is very dangerous for you because it goes exactly to the kind of arguments that you are going to try to do in these kind of competitions, and it's called ab auctoritate. Ab auctoritate means that the opinion of another person is the base of the argument. And I know, and I'm very well aware that you are required to present authorities of what you're saying in both your written and oral statements. But you have to be able to prove that an authority is an authority. And it is very common that at the moment in which we ask why certain opinion that you're presenting, certain document that you're presenting, or certain person or policies that you want to present as a subsidiary source of public international law is an authority, that you are not able to produce and present that kind of argument. The reason of the question is not other than to try to avoid this authoritative kind of fallacy. Because the sheer fact that you are going to present an article that someone wrote doesn't mean that he has the authority to do so. And if we do not question the authority, we are able, or we might, fall exactly in the fallacy that went into the scientific world for at least 25 years, in which one article described that humans have 23 pairs of chromosomes. No one actually take care on trying to review that kind of article, and from almost 20 years in the scientific community accepted that humans have 23 pairs of chromosomes. A footnote, we don't have 23 pairs of chromosomes, we have 21. But no one double check on the authority of the first author of this statement. So almost until the 1960s, we came into the realization that we have thrown 20 years of scientific knowledge down the void, thinking that we have more chromosomes than we actually did, because no one checked. So an authority has to be avoided. Ad consequentiam, that means that the hypothesis can be or should be considered true or false solely on whether the final consequences of the reasoning are desired or not. That will mean that I can tell that the argument of my counterparty is true or false because if it's true, then my client is going to go to jail. Well, that is not an argument. That's a fallacy that is built on the consequences that you don't want to do. There's another exception to this kind of fallacy, and in law it's called argumento ad conveniency, and it means that it might be valid only if we can present that the factual evidence of the consequences of that actions will be unreasonable or inconvenient or damaging. That means that you can make an argument that whether or not an argument may prevail may cause a genocide. Well, we all would like to avoid that kind of consequences. Therefore, that might be a valid argument if and only if you can present factual evidence of that kind of consequences. Good wishes or just you trying to say that out of the air are not factual evidence and will draw you back to the fallacy territory, which you want to avoid. Ad ignorantia, and this is very, very common in almost your daily life, because people are going to tell you that the proposition of what I'm saying is true and you prove me wrong. And that's a fallacy. Things are true or false without regard of if you know that they're true or false. So what this means is that you have an author episteme in which a proposition, you consider that a proposition cannot exist if the person hasn't experienced it yet. And what this means is that you have to be conscious in the way in which you are going to present your arguments to, because the fact that you are not going to be proven false at the moment in which you made your presentation doesn't mean that either the counterparty or the judges are believing it. Sometimes we remain silent and know that you are lying, and we know that you're presenting a false argument. So the fact that you are not proven false doesn't mean that your argument is good or your argument is going to prevail in any kind of court of law. Ad hoc, and this is also one of the most dangerous fallacies or kind of arguments that you can make before a court of law. That means that you are claiming that a special situation or a general or special exception to the rule applies to your case. And that will mean that you have to prove the existence of the exceptional state for that exception to exist, and that exception applies. And also will mean that you are admitting that you have violated or you have breached the main rule of law from which you're calling an exception. For example, and I'm going to very evident, I will say, examples for these kind of things. If the defense of someone is self-defense, he is somehow admitting that he has committed either a damage or he has killed someone. And that's an illegal, that's illegal by itself. And that's a breach of the law by itself. So if that person does not prevail with its argument concerning self-defense, he's going to be accepting that he made some kind of body, physical damage, or even murdered someone else. In the case of public international law, the argument that you usually do is countermeasures. Countermeasures is you are applying an illegal measure by itself. So if you fail to prove the existence of the special circumstances that give rise to that countermeasures, any and all other arguments are going to fail concerning that claim. because at that very same moment, you are admitting that you have committed an unlawful act and you have reached international law, and there's no way to go back from that. So you have to be very careful while trying to claim or incorporate into any argument any kind of uh, uh, ad hoc situation, I would say. There's also petitio principii. That means that you are going to build the premises of the propositions from the conclusion. And I know that you may think that this is exactly what you are required to do on the Jessup, because once you have now your statement of agreed facts or the compromise, what you are going to have is that you already have 4 conclusions. Well, 8, one from one side and one from the other. And you have to construe from them all the premises. Well, what this means is that also that the premises or each of the arguments and reasonings that are contained cannot be construed from the conclusion all the way up to the premises, because that will mean that the premises are going to be false. And that will imply that this is a circular reason, as the premise is going to be linked in such a way to the conclusion of the reasoning that you're presenting, that you are not going to be able to present a logical concurrence of the facts and the arguments that may go all the way to that conclusion. Selection bias. That means that the evidence that you use to demonstrate a hypothesis is selected to have an influence on the final proposition. In our case and in international law, it will mean that in this competition, it will mean that you are going to avoid certain sources of international law that will create a mistaken proposition. It is not uncommon for us to know or to see that certain, or at least only certain argument, you by some kind of mistake avoid speaking about a certain convention that is not good for your argument, or to maybe in the construction of international customary law, you decide not to speak about certain objectors or problems in the construction of international law. Well, that will mean that you are making a biased selection of the evidence that you're proving, that you're presented to prove your hypothesis to the court, and that will mean that you are presenting a fallacy and therefore a false argument to the court. You have to be able to incorporate all the cases and hypotheses that are helpful to your case, and to be able to demonstrate to the court why they don't apply, or why they will apply to another another set of circumstances are actually arising, but not in this present case. Avoiding the cases and avoiding the hypotheses that might be hurtful for your argument is going to, at the end, going to be hurtful for yourselves. So this one is called post hoc ego propter hoc. That implies that the result does not include a causality premise that may link the hypothesis with the result. What this means is that there is not something that we call the causal link, that you are missing the causal link and you cannot make an explanation on why certain things have caused precisely the thing that you want to present. So that the premises or that the conclusion does not derive directly from the premises that you're presenting. And you have to be very, very cautious about this, because correlation does not imply causality. The fact that two things happen at the same time, or that there can be a correlation between them, does not mean that one is the produce of another. And for that, I would like to make my argument about pirates and global warming. If you're able to see the graphic that you see here, you may see how, as the number of pirates goes lower from 35,000 to 17, the average temperature of the Earth has increased. So as in 1820, there was 35,000 pirates, and the median average temperature in centigrades was around 14 degrees Celsius. And right now, or around the year 2000, there were only 17 pirates, and there was an increase in the global temperature of around 2 grades centigrades. That will mean that as less pirates we have, the more global warming that we can present. This is the existence of a correlation, but this is obviously an eared argument, because I'm not establishing and I'm not presenting you any causal link on why or how the existence or non-existence of pirates may cause global warming. I'm just presenting you correlation about this. And now this one is extremely problematic. It's evidence suppression. I would say it's one of the worst things that you can do, not only in the competition, but also in presenting any kind of legal argument. And it means that you are presenting a misleading proposition in which only half of the truth is presented. The most common tactics, if you start quoting partially, they make this contextualization of what you are presenting, or you're trying to present a different meaning to a word. I would like to give you an example of one of the, I will say, issues I had the past year with the Jessup problem. There were several teams that were telling and that were trying to present that the Nicaragua case, the case of our farmer killed in and around Nicaragua, it's in it the court said, and almost well, several teams tried to say that at that case, the court said that the crime of aggression was considered as jus cogens by the ICJ. That's both quoting partially and at the contextualization of what happened. Because if you read the next paragraph, you will see first that within the context, it was not said by the court. It was the court saying that Nicaragua has presented an argument that referred that the crime of aggression is forbidden by a matter of jus cogens. So the context was not court saying that. The context was that the presentation or just the enumeration, the listing of the argument by the court. And also it was a partial quote, because in the very next paragraph, the court said, and we are not going to make any ruling about that argument because we have already solved the whole controversy. So not only there's a partial quote, there was also the contextualization of the quote. And obviously that brought several troubles to the teams that tried to do it. Because as I said at the beginning, this kind of fallacies, when presented to a court, can be understood by either that the team is ignorant about the context and the reasoning that is being presented to them, or that they are being malicious and they're trying to trick the court or to trick the judges into their argument. Neither of those are going to be a good solution or are going to present you with a good outcome for your arguments. Basically, those are I will say those are the 10 most common fallacies that you must avoid, and you have to work all together with each other in order to avoid them. And in order to do this, my advice is that you have to divest yourselves of all your egocentric tendencies. And you have to be able to understand that the argument for the sake of the argument has to be correct, and that if someone is going to uh, correct it, you have to accept it. You all know, and we all know, that you have worked very hard, but the fact that you work very hard in something doesn't mean that it's correct or that is true. And you have to be, and we all have to be humble enough to understand that, and understand that the correction that are being made by all your teammates or by your faculty advisor, coaches, or any other person are almost all the time aimed to prevent these things. I think that's all my presentation. Thank you very much.
Thank you, Rafael. Thank you.